on behalf of Judge Stafford and Judge McGee, we want to welcome Mr. Tootin, Mr. Beamer, and Mr. Lyons. And we are thankful that you are participating in this live streaming oral argument today. Please understand that we will conduct the hearing in the same fashion as we would if all of us were in the courtroom together. Also, the appellant and the appellees have 15 minutes each. And if the appellees are going to split their time, you'll need to tell us how much you're going to do with that. And the appellant, of course, Mr. Tootin, has the right to reserve some time for rebuttal, and I understand he has already done that. Unless there are other comments or matters, Mr. Hibner, please call the case.
Antaveon Waller versus Varangon Corporation doing business as Varangon Academy et al.
Thank you, Mr. Hibner. Mr. Tootin, you have the floor.
Yes, one moment. So and again, this attorney Tootin, I represent the appellants in this matter from Shelby County, Tennessee. Basically, this issues that we're going to raise has been thoroughly laid out in the briefs, but I will highlight a few things. One, as it relates to Varangon Corporation, basically their position is that when the appellant sued Varangon, they basically sued the wrong party. I will address briefly some of the arguments that appear to be made in the appellate record by opposing counsel for Varagon Academy, where they're making the argument, at least I'm interpreting them to make the argument, that there was no proof put on regarding causation, and therefore, basically, the appellant has no leg to stand on. And what it appears they're arguing is that there was no expert or medical proof explaining the injuries and connecting them specifically to Varangon's conduct. But I want to address that to say, if you look at their motion for summary judgment, the motion itself, specifically on paragraph number 3, talks about how their argument is, and it says specifically their argument is that the appellant sued the wrong entity. That was the basis of their motion for summary judgment. If you look at their undisputed facts and you look at the memorandum, it is consistent with that argument. So there was no issue raised requiring a response to be made regarding medical proof, because the issues raised by Varagon Academy was the correct entity sued, and their argument was no, it was not. So I would ask the court to defer to the record, but to the extent they're making the argument that we failed to produce that information, the answer is simple. That was never raised and is cited to with any citations to the record to make that assertion, which would require the appellant to even address that issue, because that wasn't the issue. The issue was the proper party sued. Again, the undisputed facts are very clear. The motion is very clear. So that's not an issue. In addition, the appellant has raised an issue that opposing counsel seems to take issue with, and we would like the court to clarify this, because we believe we're clearly right on the law on this. And one of the grounds we raised, and we referenced it in the amended complaint and in the motion to set aside, is that the appellant also raised the issue of whether Varagon was responsible under their liability under child neglect. And we cited a TCA that cited the TCA criminal code. Now, opposing counsel seems to believe, and again, the court will inform us who's right on this, but they seem to believe that because a criminal code is cited, and obviously this is a civil case, then essentially the plaintiff, so the appellant, has basically raised no argument, because obviously a civil case does not rely on the criminal code. It is our position that we believe that's a misunderstanding of the law, that when you're determining negligence, whether there's a duty, breach, causation, or damages, being able to prove that they violated a criminal code as it relates to child neglect is in fact a basis to find a party in a civil lawsuit negligent. To the extent we're wrong on that, we do not mind the court telling us that, but we think the law is very clear. And I've had several cases where that is a basis used to support the argument of negligence. So the reason that's important is because when the court granted the motion for summary judgment, it did not touch that issue at all. So that issue was not raised in the motion for summary judgment. So is our position, how then could it have been granted in the motion for summary judgment as a motion on all issues? Because that is another type of negligence in which we were arguing. So I wanted to be clear on that as well. In addition to that, we go on to talk about Varagon Academy. The problem we have with Varagon Academy is our position, as we laid out in the brief, is that we do believe the appropriate and the correct party was served. When we, as the appellants, filed a motion for default judgment against Varagon Academy for failing to timely respond, there was a response provided by Varagon Academy representing themselves to be the party in this case, in which the attorney for the Varagon Academy who did that response is the same attorney now. So that was used to keep us from being granted a motion for summary judgment. There also a notice of appearance was done saying Varagon Corporation doing business with Varagon Academy. So there's no question that those representations were made. And then when we did our discovery responses or discovery requests, they were answered on behalf of Varagon Academy as in the party to this lawsuit, signed, sworn to under oath by Robert Wood, the same party now saying that this was the wrong entity and that the appellants sued the wrong people, using the same attorney with the same party after making previous and multiple representations to the court that they were in fact the same people. When this issue was raised by the trial court did not feel comfortable addressing it as we laid out in the brief, and then it basically said they would not address it and will leave it to the Court of Appeals to deal with that. And we specifically asked the court to make these rulings, to make these specific findings of fact so that we can be all clear where we stand on these issues, and the court declined to do so. Therefore, I believe it is appropriate for this court to address these issues de novo. But again, when you're talking about whether or not there's a disputed fact as relates to summary judgment, and there are multiple issues where there's a disputed fact as to if Varagon Academy was the owner of this building or Varagon Corporation, then that's something for the jurors to sort out. As it relates to Omnivision, my understanding of their position was basically by the time you filed a lawsuit serving us, the statute of limitation had already run. So basically, I understand their argument to be too little too late. The problem is this incident happened at Varagon Academy. The question is, was Varagon Academy owned by Varagon Corporation or Omnivision? But there's no dispute that the pre-suit notice was sent to a representative for Varagon Academy who received it and then basically gave it to the appropriate party. So no one is arguing that the owner of Varagon Academy did not receive this information. I believe the argument is, and I don't want to mistake the argument, they can tell me if I'm wrong on this, but I believe the argument is you didn't send it to the right place or to the right people, which again would not only be a disputed fact for the jury to determine, but there's no dispute in the ultimate issue of substantial compliance that it went to a party on behalf of Varagon Academy and got it to the appropriate people. So I don't think there's an issue at all. The fact that Omnivision's name was not on the complaint, but Varagon Academy's name was, creates a relation back issue under Rule 15, a civil procedure where you just go and amend the complaint to name the party who owns Varagon Academy. That's basically all we have is a relation back issue, because no one is disputing, and it's never been disputed, that Varagon Academy received this information and then gave it to the appropriate party, whoever that party may be. So with that said, if there's not any questions, I'll stand primarily on the brief. I don't want to reread the brief.
All right, thank you, Mr. Tootin. Which of the appellees is going first, and how much time will you take?
Thank you, Your Honor, and may it please the court. This is Louis Lyons on behalf of Varangon Corporation. We will go first, if that's all right with the court, and we will take half of the time. So,
all right, if you will, Mr. Hibner, set the clock for 7 or 7.5 minutes, whichever works. There we go, 7.5. You may proceed.
Thank you, Your Honor. May it please the court. I think it's important in this case to begin with making sure that there's complete understanding with respect to the two legal entities that are the named defendants in the case. I represent Varangon Corporation, which was initially sued in the case as Varangon Corporation or Varangon Academy. As is set forth in the record in the case and in our brief, Varangon Academy is a trade name that is used by the legal entity Varangon Corporation. In 2014, Varangon Corporation sold the facility that this incident occurred at to Omnivisions Incorporated. Omnivisions Incorporated bought the real property and bought certain intellectual property. Some intellectual property was retained by Varangon Corporation, including the trade name Varangon Academy. There seems to be some confusion in the court below regarding the corporate status of Varangon Corporation and whether, in fact, it is distinct from Varangon Academy. And the Varangon Academy was the name of the location, but it was also the name of the directive therapy system that was the essence of what Varangon Corporation sold to and licensed to Omnivisions. So to be clear, Omnivisions Incorporated is a wholly distinct entity from Varangon Corporation. Varangon Corporation and Omnivisions Inc. are the only two legal entities capable of being sued that have the capacity to be a real party in interest in the case. So I think it's just important to orient ourselves for the rest of this discussion regarding the nature of those corporations. Now, we made reference to the sale of and the asset purchase agreement, which was part of the record on summary judgment. It is our position that the trial court was correct to grant summary judgment to Varangon Corporation on the basis that it owed no duty to the plaintiff in this case under the facts alleged. The facts essentially were undisputed and largely were based on the contract terms of the master services agreement and of the asset purchase agreement, which were the two contracts that govern the relationship between Varangon Corporation and Omnivisions after the sale. All of the acts complained of in the complaint and that upon which plaintiff bases his claims are post-sale actions. The sale occurred in 2014. The plaintiff did not become a resident until 2016. So there's no question that the acts of negligence that serve the basis of the complaint occurred after the sale. The contracts and agreements make clear that Varangon Corporation owed no duty to the plaintiff. That was the essence of the trial court's grant of summary judgment. Clearly, the question of the existence and scope of a legal duty is a question of law for the court that is properly decided on summary judgment, and the trial court was correct to find that there was no duty in this case based on the terms of the agreement. There was also no factual basis upon which the trial court could have relied outside of the contract terms to establish a duty. There was no dispute that all of the nurses who provided care to the plaintiff in this case were employed by Omnivisions, not Varangon Corporation, that Varangon Corporation did not provide any training or medical in the medical field to any of the OVI employees. And there's no dispute that the crux of plaintiff's negligence claims in this case relate to the provision of nursing services, the failure to diagnose a condition, the failure to provide or secure transport for more acute treatment. Therefore, based on the undisputed facts, based on the contract terms at issue that were all part of the summary judgment record, there was no duty, which is an essential element of plaintiff's healthcare liability claim. In his argument, the plaintiff indicated that Varangon Corporation did not assert causation as a basis, an additional basis upon which the court could find that summary judgment was proper. However, at page 103 of the record, which is at paragraph 3 of Varangon Corporation's motion for summary judgment, it clearly states that there are two elements of plaintiff's claim that he is unable to support at the summary judgment stage. duty and causation. The crux of the argument was what we had just gone over, that plaintiff did sue the incorrect entity. However, we still asserted that plaintiff had an obligation to come forward with evidence sufficient to create an issue for trial on the issue of causation. He failed to do so, and the trial court properly granted summary judgment on that basis as well. Again, that is an alternative basis, and of course, it should be axiomatic that the plaintiff has an obligation to establish sufficient facts to support a finding on each of the essential elements of his claim. And therefore, our causation position is an alternative position where duty being the primary argument in the case before the court. With respect to the child neglect statute that plaintiff alleged in the complaint, our position is that plaintiff waived that issue on appeal. I do not believe that it was addressed at all in the appellant's brief. We did not address it accordingly in our response brief. If the court is inclined to find that that issue has not been waived by the appellant, we would be pleased and happy and welcome the opportunity to provide additional briefing on that. But in essence, the child neglect statute does not create a private right of action, or and to the extent it is in derogation of the common law, should be strictly construed against changing the common law. And so that this is, in essence, is a common law case with respect to negligence. At the end of the day, there is simply no proof that any actions or inactions on the part of any Varangon Corporation employees violated any standard of care, nor is there any indication or proof or legal basis upon which to find a duty was owed by Varangon Corporation to the plaintiff. And for those reasons, the trial court properly granted summary judgment. The additional issues that were raised in our brief, we will stand on unless the court has any other questions. It appears our time is up.
Thank you, Mr. Lyons. Hearing no questions, we'll now hear from Mr. Beamer on behalf of Omnivisions Incorporated.
Thank you, Your Honors. Mr. Lyons gave an accurate description of the relationship between Varangon Corporation and Omnivisions as it related to Varangon Academy. So as of the time that the plaintiff filed his original lawsuit, he was still 18 years old. He had been a resident at Varangon Academy, which at the time he was a resident was owned by my client, Omnivisions. The pre-suit notice letter that plaintiff's counsel sent to Varangon Academy in 2016, and then there was a supplemental notice sent in 2017. That notice was, again, addressed to Varangon Academy, not Omnivisions. It was sent to the registered agent for Varangon Corporation, Dr. Robert Wood. And it was not even sent to the physical address for Varangon Academy. So basically all of the plaintiff's arguments on appeal are anchored by the argument that this pre-suit notice to Varangon Academy was effective as to Omnivisions. So it's indisputable that the plaintiff did not name Omnivisions as a defendant until 120 days after the one-year statute of limitations for healthcare liability actions ran on his 19th birthday. So the plaintiff is taking the position that pursuant to section 29-26-121, the amended complaint naming Omnivisions as a defendant was timely filed. Your Honor, it's our position that the trial court correctly granted our motion for summary judgment on statute of limitations grounds. Law is clear that providing timely written pre-suit notice directed at each party to be named as a defendant is mandatory, and that strict compliance is required under the statute. The plaintiff has argued in his brief that substantial compliance is required. We believe that he's mistaken. Again, the pre-suit notice was not directed to Omnivisions, did not name Omnivisions by name, was not sent to Omnivision's registered agent, was not sent to Omnivision's principal place of business. In basically, Your Honors, looking at the case law that have construed the pre-suit notice requirement and strict compliance with the statute, the court has found that claimants who came much closer to complying with the statute than the plaintiff did here still failed to comply with the statute. In particular, the Runyon's case, Shockley, and then this court's opinion from last week in the Webb versus Trevecca Center for Rehabilitation case. In all those cases, the pre-suit notice was sent to the right location, the right address. Basically got in the hands of the right person, either the registered agent for the correct entity or their general counsel. But in each of those cases did not name the correct entity that was sought to be added as a defendant. And for that reason, in all of those cases, the court found that the plaintiff had failed to strictly comply with the requirements of the pre-suit notice requirement and dismissed all of those cases. So in here, it's just really not even close. The pre-suit notice did not name Omnivisions, was not sent to Omnivisions, either registered agent or to their principal place of business. And it's our position that the failure to do so before the statute of limitations ran is fatal as to the plaintiff's claims against Omnivisions. And again, it's important to note that the plaintiff was aware of Omnivision's identity based on the answer that Varangon Corporation filed approximately 6 weeks before the statute of limitations ran on the plaintiff's 19th birthday. So, Your Honor, for these reasons, we believe that the trial court correctly found that the statute of limitations had run as to Omnivisions based on the failure to provide pre-suit notice to Omnivisions. Your Honor, a couple arguments that were raised either at the trial court level or in the briefs, I'll just briefly touch on since I've got a little bit of time. The trial court found that in its answer, Varangon Corporation had alleged comparative fault against Omnivisions. Again, that was done approximately 6 weeks before the plaintiff's 19th birthday. The plaintiff has argued that as a result of that, pre-suit notice wasn't required as to Omnivisions, but the plaintiff really section 20-1-119 would not have applied here for a couple of reasons, not given the plaintiff any relief for a couple of reasons. One, Varangon Corporation filed its answer before the statute of limitations had run as to Omnivisions, therefore section 20-1-119 would not have applied. And even if it did, the plaintiff did not amend his complaint to add Omnivisions as a defendant within 90 days of the filing of Varangon Corporation's answer. So that does not give the plaintiff any relief here from the fact that his claim was time barred. The motion that the plaintiff filed to set aside the court's order granting summary judgment to defendants, we believe there was no abuse of discretion by the trial court there. One of the issues that the plaintiff attempted to relitigate through that motion that could have been raised on summary judgment was the relation back issue. Again, the problem with the plaintiff's relation back issue is that he never provided pre-suit notice to Omnivisions in strict compliance with section 29-26-121 before the statute of limitations had run. Your Honor, we believe that the trial court was correct in its ruling on the statute of limitations as to Omnivisions, and we ask the court affirm that opinion on appeal. Thank you.
Thank you, Mr. Beamer. We'll now hear rebuttal from Mr. Tootin.
Yes, just a couple things. One is we do believe there's a question as to whether or not comparative fault was even raised by Varagon Academy or Varagon Corporation, and that's laid out in our brief. But to set aside, but to focus, to hone in on this issue that Omnivision raises about the strict compliance versus substantial compliance, again, it is, I don't know if I can say it enough, and I don't know if the record the record clearly repeats this over and over and over again. When there's an incident that happens at Varagon Academy, and the question is who owns Varagon Academy, then the question before this court is simple. When Varagon Corporation files something with this court through Attorney Lyons, who says this is Varagon Corporation doing business at Varagon Academy, the simple question is, what does that mean? What is that purported to mean? And does that create a disputed fact about ownership? Then when discovery responses are given, or discovery is sent out to Varagon Academy or the owner of Varagon Academy for discovery, and Attorney Lewis Lyons, on behalf of his client, says these are responses on behalf of Varagon Academy, the party to this lawsuit. What does that mean? What is that intended to mean? Does that create a disputed fact? Because if the position is now that Attorney Lyons or Varagon Corporation never had authority to speak on behalf of Varagon Academy because it was owned on behalf of Omnivision, then the obvious question is, then why were you doing that? Why were there multiple representations made to court through filing? Why was a motion for default judgment thwarted due to the representations made that this Varagon Corporation doing business with Varagon Academy was stepping in essentially to prevent that from happening? So when that entity is then given pre-suit notice on behalf of Varagon Academy, then the question is that substantial compliance, and is that sufficient in this case? And again, to this argument that appears, I believe he said it was on page 103, and I think we both are citing the same point on the motion where he's saying that it was this alternate argument that causation was an issue. And he cites the paragraph 3 that specifically says the issue is an entity was the wrong entity sued. Even if we take that position as true, that you referenced it in your motion as an alternate argument, as the court is well aware, you still would have to support that argument through citations to the record, through undisputed facts, and things of that nature. It was never done. So you just don't get to blurt out a quote unquote alternate argument and then leave it unsupported and say that it should stand. To the point to where the position is, well, we didn't know that the issue of the negligence as it relates to child neglect would be raised and that's waived. The problem with that is there's no dispute when dealing with summary judgment. It's a de novo review. The court reviews this de novo. They look at the complaint, they look at what occurred, and then the court makes a decision. It is not waived. It is something that was pled in the amended complaint. It was something that was never addressed in the court when it issued its ruling. And so the question becomes, how can that be a ruling over all allegations? It is a form of negligence that we raise. It is something that the court would consider through de novo review. And again, as it relates to the motion to set aside, when you have a hearing on that and the judge says on the record that they're not going to address all the issues being raised and that they don't feel comfortable or that they don't believe they're in a position to, or that they believe the Court of Appeals should do it, how does that not create a scenario where this doesn't get reviewed de novo? So for these obvious reasons, we'd ask that your honors grant the relief sought by the appellant.
Thank you, Mr. Tootin, Mr. Beamer, and Mr. Lyons for your arguments. We will take this matter under advisement. Mr. Hebner.
This honorable court is now in recess until 2 p.m.